Indigenous peoples around the world are using many strategies to defend territories from large-scale developments they disagree with. One of these strategies is the use of the law.
Across the world, there are now international laws that protect you. There are also laws that protect you as a citizen in your nation. You are part of the population, part of the nation, and you can use these laws to fight for your rights.
Communities are using national law, regional law, and international law to fight against the takeover of their lands. This video will look at how the law is being used by communities in 3 countries, Indonesia, Tanzania, and Paraguay, and investigate what the risks and advantages are of going to court. Our first story comes from Indonesia and tells of a recent successful legal challenge by indigenous peoples to the national forestry law. Under the law, 70% of Indonesia's land area, including most indigenous territories, were claimed by the Ministry of Forestry as state forest lands. For years, the forestry law had been a major reason for indigenous peoples being criminalized for just living on and using their lands.
There are many indigenous lands, including customary forests, which are unilaterally claimed by the Ministry of Forestry as state forest lands. This then created overlapping claims leading to numerous conflicts. Many can be categorized as human rights violations.
These conflicts led the communities of Kuntu and Chizitu bringing a case to the Indonesian Constitutional Court to find out whether the forestry law was legal under the Indonesian constitution. After much organizing, lobbying, and campaigning, Constitutional Court's ruling number 35 recognized that the ancestral forests of indigenous communities are not state forests.
Of course, the struggle is still long after the Constitutional Court's ruling. The ruling is not enough but must be strengthened by other legal instruments. Above all, we need to accelerate the adoption of the law on the recognition and the protection of indigenous peoples.
Supaya RUU pengakuan dan perlindungan masyarakat adat itu segera disahkan.
We can see from this example that Indonesian indigenous peoples are successfully using the law to challenge unjust laws. But for these legal victories to be translated into real improvements for the indigenous peoples themselves takes continued mobilization and organization. Our second story comes from Tanzania, Africa, where the Maasai people also went to the national court to question the legality of the loss of their lands to national parks.
We were trying to challenge, why is it that the Maasais are evicted in their villages? Is it constitutional? We were trying to challenge, why is that the companies are heavily supported by the military in Tanzania, especially when it comes to the indigenous people territories. We were challenging the mass violation of human rights. People being shot, people apprehended, livelihood being destructed. And we wanted the clarity of the court, whether this is constitutional.
The Maasai movement supported their court case by ensuring community unity and as much community involvement as possible.
So we made effort to attend the court as communities, to see at least, even if we are not speaking or we are not interfering, but to see what is happening and what is being said. Community also equally contributed their financial resources to support also media that was informing the public about how the cases were being run.
However, the Maasai found that going to court to defend their territory can have limitations.
Court is really expensive in terms of money to get the lawyers. It is also expensive in terms of time. It's technical. You've got to have the right lawyers. You've got to have the resources so that the lawyers cannot be corrupted and the other way around. But we have also seen the private sector, the companies, and they can actually influence even the court. They can influence the running of the court.
This court case was first launched in 2010 and still hasn't reached its conclusion. Meanwhile, the Maasai people continue to be harassed and evicted from their lands. With high expenses, delays and problems in implementing court decisions, it is important to be aware of the difficulties in using the law to defend your territory. But in many cases, taking legal action can be a positive experience. Several indigenous peoples have obtained recognition and rights to their lands through national and international courts by demonstrating their deep cultural connections to their territories. Many cases of this kind have been brought to the Inter-American Court of Human Rights, which gives communities in 35 countries in the Americas the option of taking their own governments to court over land and human rights issues.
The Inter-American human rights system has been used a great deal, especially in the last dozen years or so, by communities who feel that a range of their human rights, including the right to property and culture and life and health, are being violated by these projects.
Many communities in the Americas have successfully won cases at the Inter-American Human Rights Court and forced their governments to respect their rights. Our third story comes from one of these communities, Sawayamaksa in Paraguay, who recently won their case for their ancestral lands to be returned.
The cattle rancher took control of our lands and deforested 3,000 hectares of our forests. We didn't have the freedom to keep our culture going. We went to the Inter-American Court of Human Rights, and the court recognized our rights as an indigenous people.
The court made it clear that the Paraguayan state had not lived up to its responsibilities to indigenous peoples, above all, in relation to the fulfillment of indigenous rights and guaranteeing good standards of life.
The court ordered the Paraguayan state to return Sawayamaksa their ancestral lands. The ruling, however, took 8 years to be enforced, and only then after much pressure from the community and its supporters.
As we know, with all indigenous struggles for land or territory, the judicial option is only one of many options. We see that here there was also a strong political element.
We had to fight on paper, using protests, blockading roads, demonstrating in front of Congress and government until they would recognize our claim.
Their case is a symbolic case that should benefit other communities. The interpretation the Inter-American Court of Human Rights made over the rights to communal property will serve others in other countries.
The victims who go through a judicial process in defense of their rights are victims that win because they have had the capacity to stand up to the perpetrators face to face in a court of law. So these long struggles generate much dignity and respect, both nationally and internationally.
International human rights law is also being used to support the rights of indigenous peoples. Treaties such as the United Nations Declaration on the Rights of Indigenous Peoples and the International Labour Organization's Convention 169 both prohibit the forced dispossession of indigenous territories.
There are ample protections in international human rights law for indigenous peoples. These can be used by lawyers to argue for not just fundamental rights of information, participation, consultation, access to information, the right to your property, your culture, your life, and to health.
The way in which the law can be used by communities will differ from country to country, as each nation's laws are different. Regional law bodies vary from continent to continent. International law can be hard to enforce, and many countries are not signatories to the treaties that support indigenous people's rights. Using the law to defend your land rights often works best when backed up by several other strategies. Community awareness raising, mobilization, communication strategies, protests, and networking all serve to complement legal challenges and help its success.
People shouldn't think that these problems can be solved by a lawyer. Without doubt, I think the work lawyers do is important, but the ones to have the capacity to argue the case, take their truth in front of the courts and public opinion, have to be the communities themselves.